Welcome to Court TV on Crestview Community TV. I'm Ryan Hardy, your Crestview Community TV legal analyst, and today you're watching Docket Day. Now, Docket Day, last year and in previous years, it was the biggest court date. Now we've added a court date with pretrial conference happening the week before Docket Day, so Docket Day has shrunk down and gotten somewhat smaller. However, you're still going to see defendants who maybe have been in court for the first time, maybe their appearance was waived at pretrial conference, which we spoke about in that video. But when someone's called to the podium, you're going to see, again, one of a few things can happen. They can enter a plea. At that point, the case would be over, and they'll get sentenced either today, live on Crestview Community TV, or they'll get sentenced in a sentencing hearing down the road on one of those miscellaneous dates that we'll talk about in another video. They could also ask to continue the case. At that point, it would get set to another cycle 6 weeks down the road. The last thing they could do is they could announce ready for trial. And that means, hey, we're ready, when we're going to send this case to a court date called jury review. And then from that point, the case will get sent to a jury trial. And I know that's what we all really, really love to see. Those obviously are rare. They don't happen a lot. But we all get excited when we hear that, ready for trial.
Ronald?
Hello, Mr. Phillips.
Good day, sir. I'm sorry, I didn't mean to fold it up. I thought it was my...
That's okay.
There's no peanut butter on it, so we're good to have. Your Honor, this is Mr. Ronald Phillips.
Yes, sir.
We do have a resolution on one of his two cases in 21 CF 3045. That is a misdemeanor, or that's a violation of probation. Mr. Phillips and the state, today's 5/15.
Yes, sir.
Have agreed to resolve that particular case. And the resolution on that case is going to be that Mr. Phillips will enter an admission to violating supervision in 21 CF 3045. He will be sentenced to time served in that particular case. His probation will be terminated, revoked and terminated. He'll be assessed a $100 cost of prosecution, $150 in public defender fees. He was previously adjudicated. As part of that, and this is why it's being resolved the way it is, in 23 CF 625, that's the new law violation. We're going to ask to continue this to the July 10th docket. However, the state would agree at this point to reduce Mr. Phillips's cash or professional bond in that case to $5,000 signature bond. But that's not on the plea agreement. If I'm being approached with a plea agreement.
Okay. Is that the state's agreement?
That is the state's agreement, Your Honor.
Thank you, sir.
Mr. Phillips, if you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Thank you, sir. You can put your hand up. Mr. Phillips, did you read the plea agreement?
Yes, sir.
Do you understand it?
Absolutely.
Did you sign it?
Yes, sir.
Mr. Phillips, I do accept your plea. You're adjudicated guilty. Your prior supervision is revoked and terminated. You're sentenced to credit for time served. You need to pay the $100 cost of prosecution, $150 public defender's fee. How long will it take you to pay, well, after you get out, how long will it take you to pay the outstanding financials?
Can you give me 60 days?
Yes, sir. Why
That's
don't
for
we
the
do-
150 plus the 100, correct?
Right, I don't know, do you owe anything else, probation? Do you know if he owes?
How will I go about knowing exactly how much I owe?
Let's see.
What can I look up on the internet to find that out?
Probation should let you know.
Probation and parole?
Yes, sir.
Okay, thank you, sir.
Um,
I'll go check them out. And
Why don't we say 6 months, Mr. Phillips, okay?
sounds good to me.
So all outstanding financials will go to a civil lien or judgment 6 months from the time that you're released from either jail or prison, okay?
And just to understand, does this signature bond mean I sign it or does somebody need to come
You
sign
sign
it?
it.
Okay.
You sign it.
So, Mr. Phillips, it looks like you owe $370 in court costs on that case.
Plus the 150, right?
It's an or
Yes,
tennis
sir.
motion.
Correct.
So about
So on 23,
About 400?
About
6
600.
months is fine. 6 months is fine. Thank you, sir.
23 CF 625, the new case, the oral motion, because of the stipulation of the state, is granted. It's a $5,000 signature bond. So you'll be able to sign yourself out today, Mr. Phillips. I'll see you back here no later than July 10th at 9 o'clock.
That's
on
my
the new
date.
case.
that's your court date.
Okay.
July
That's why I
10th.
gave you that card.
Stay in touch with Mr. Clark.
Call
Yes,
me
sir.
when you get out.
Do I have anybody I need to check in with weekly or anything like that?
Your probation is over.
Okay, all right, thank you.
Let me just,
I just want to make sure. I don't want to
Good.
mess anything up here.
does not appear these are
Okay.
pretrial services of any kind.
Thank you. God bless you guys, and thank you, sir.
Next is Spence Phillips. Other Mr. Phillips.
Hello, Mr. Phillips. Good, how are you?
Your Honor, we had announced ready for trial in 21 CF 2816. We'd like to leave this on for the jury trial docket.
Okay.
And I, just so the court's aware, we are trying to work some kind of resolution out here, so.
Okay. To the state, is there any offer to Mr. Phillips that you intend to withdraw today?
No, Your Honor. I'm in constant communication with Mr. Klein about this, so we're going to leave it open.
Okay, so Mr. Phillips is going to come back on Thursday?
Yes, sir.
That's correct.
Does the state intend to withdraw any offer on Thursday if it's not accepted by Mr. Phillips?
Yes, Your Honor.
Okay. So, Mr. Phillips, your homework is between now and Thursday. If something else doesn't work out, just know that the state's going to withdraw whatever offer they've made to you, and then we'll be going to trial either next week or a couple weeks after. So your homework is figure out if it's in your best interest to accept the state's offer, okay? And I'll see you back here on Thursday morning.
Yes, sir. Thank you.
Thank you, sir.
Next is Adrian Rico Garcia.
Charles Russell, Public Defender's Office for Mr. Garcia, Judge. He's number 102 on your docket, but he is also number 105.
Okay?
It's the same man. Case numbers are 19 CF 2475 and 22 CF 2966. The notes that I have are that the state trying to verify restitution, so we're asking to pass to Thursday, and if we can get that amount, then we may be able to settle it then. If not, the plan is to continue.
Okay. And I saw, when I was doing my homework, Mr. Garcia, I saw that you're on here for a VOP, but I didn't see, when I printed it off, it was 104. Got it. And it's also 107. Okay.
Oh, you have a different docket than I do.
Good.
102, 105 on mine, Judge.
So is there an offer to Mr., well, we had plea or continue, we're not looking at going to trial?
Right, they're just trying to work on restitution. If we can work that out, then we may resolve it Thursday. If not, it'll be continued then.
Okay. Mr. Garcia, I'll see you on Thursday, okay?
This coming through, sir?
Yes, sir.
All right.
Correct.
Thanks.
Thank you, sir.
Next is Christina Rivas. Christian.
No probation, right? No. Straight up 24 months, credit for all time served. Go ahead, sign the date. I'll get the states.
Your Honor, this is Mr. Christian Rivas. He does have two cases, 22 CF 8. Today's 5/15/23. 22 CF 826 and 22 CF 1582. Mr. Rivas has reached an agreement with the state to resolve both of these cases. Every one of these counts is a felony count, Your Honor. So Mr. Rivas is going to be entering a no contest plea as charged. The agreed upon sentence is that Mr. Rivas will be sentenced to 24 months in the Department of Corrections with credit for all time served. He would be assessed $615 in court costs for each case, a total of $250 in public defender fees. He's previously been adjudicated. He would be, he would be adjudicated on all of these counts, and that's about it. May I approach?
Yes, sir.
I think the plea agreement, I forgot to write 615 court costs times 2, so that's just.
Yes, sir. Thank you. Mr. Rivas, if you'll please raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you, sir. You can put your hand up. Mr. Rivas, are you currently under the influence of any drugs, alcohol, or medication?
No, sir.
Have you ever been treated for any mental illness or emotional disturbance, or are you suffering from any of those at this time?
No, sir.
How far did you go in school?
11th grade.
Did you read the plea agreement?
Yes, sir.
Do you understand it?
Yes, sir.
Did you discuss it with your attorney?
Yes, sir.
Did he answer all of your questions?
Yes, sir.
Are you satisfied with his representation?
Yes, sir.
Did you sign the plea agreement?
Yes.
Do you understand that if I accept your plea, that you're waiving your right to trials by jury?
Yes.
Do you believe it's in your best interest to enter the plea?
Yes, sir.
Are you entering the plea today freely and voluntarily?
Yes.
Has anyone forced, threatened, or coerced you into entering the plea?
No, sir.
Has anyone promised you anything other than what Mr. Klein's just stated today on the record?
No, sir.
Mr. Rivas, I do accept your plea. I find that you're alert and intelligent, that your plea is freely and voluntarily entered, that you understand the nature of the charges against you, and are represented by competent counsel with whom you state you are satisfied. I find that there is a factual basis for acceptance of the plea. You're adjudicated guilty. You're sentenced to 24 months with the Department of Corrections, and that's with credit for all time served, and that's to run concurrently, run at the same time between each case and count. All monetary assessments mandated by statute or county ordinance are imposed. That's the court cost. Total of $250 public defender's fee. Those amounts will go to a civil lien or judgment. Mr. Rivas, you do have 30 days to appeal this judgment and sentence. If you wish to appeal, it must be in writing. If you can't afford an attorney to represent you for that appeal, one may be appointed for you. Do you understand your appellate rights?
Yes, sir.
Thank you, sir. Good luck to you.
Thank you.
Next is Joshua Rogers.
Judge, this is Joshua Doyle Rogers, case number is 22 CF 1852, Charles Russell Public Defender's Office, standing in for Jason McKinney. The state is trying to verify restitution information from the victim. We'd ask to pass this to Thursday to see if we can resolve the case. If it's not resolved Thursday, plan is to set it for trial.
Okay. So, Mr. Rogers, I'll see you on Thursday. Before you go anywhere, let me ask the state about a plea offer. Is there any outstanding plea offer to Mr. Rogers?
Yes, Judge. So at this point, the situation is we're looking to accept a counter offer from the defense, but the number that we have for restitution, my understanding is that number is going up, but I don't have a final from her. We had been in communication last week. She was supposed to be getting me the additional information that I needed, and I just haven't received it yet.
Okay. So, as far as revoking any offer, Mr. Rogers, the reason why I ask these questions is if the state says on Thursday we're going to withdraw any offers that we have to you, I want to tell you now or you can think about it.
Yes, Judge. If there's not an agreement come Thursday, then we will withdraw any offer. We do have subpoenas already out for the trial. I will represent to the court that my victim's agreement in this is tenuous at best. She's still very angry about the entire incident. So I do want to be quite clear about that in this scenario.
Okay. So, Mr. Rogers, I'll see you on Thursday. If it's not resolved then we'll be going to trial either next week or a couple weeks after that. Okay. Thank you, sir.
Next is Payton Thomas.
Sorry, Your Honor, I'm a little late.
Okay. What's your name?
Johnny Santiago.
Your Honor, this is Mr. Payton Thomas. He does have two cases on the trial docket. Mr. McKinney's indicated he would like to leave these set, and the intention is to try one of these cases the first week and the other case the second week. But if we could just pass Mr. Thomas to the Thursday jury review date, Mr. McKinney will address the court then.
Okay. Does the state have an offer to Mr. Thomas that the state intends to withdraw on Thursday if he doesn't accept it?
No, Judge, not at this point. There should be no offer.
Okay. So, Mr. Thomas, I'll see you on Thursday. We'll look at scheduling up the trials for next week, I guess, and then a couple weeks after that. Okay, so I'll see you Thursday. Thank you, sir.
Thompson, last name?
Michael Thompson.
Okay, this is Mr. Michael Thompson, Your Honor. I just provided Mr. Thompson some pictures that were in the file, so he can have a chance to review those with Mr. McKinney. Unfortunately, I don't believe, I did reach out to Ms. Davis last week and proposed an offer on behalf of Mr. Thompson. The state's not inclined to take that at this point. This was not announced plea or trial. This was announced plea or continue. When in speaking with Mr. Thompson at the jail last week, he has expressed a strong desire to have a motion to suppress filed, and I was just telling Mr. Thompson that I'll talk to Mr. McKinney about that. All I can do at this point is ask for a continuance, so see if Mr. McKinney can get that motion filed set for a hearing next month.
Okay. Mr. Thompson, do you agree to the continuance?
Yes, sir.
I'll see you back here no later than July 10th. Thank you, sir.
Good luck, man. Okay.
Next is Justin Tipton.
Charles Russell, Public Defender's Office, standing in for Jason Green. Judge, this is Justin Tipton. He has only 2 cases on the docket, 22 CF 1419 and 23 CF 331, but I have a plea agreement that covers other cases. 22 CF 120, 21 CF 3157, and 21 CF 3177. We had to add something to it, so if I could explain that for the record, just so that when you get it, it'll make sense. Basically, the agreement is to put him on probation so that he can complete Keaton. So on 22-14-19, 22 CF 120, and 21 CF 3157, he's going to admit those violations. He's going to reinstate to his original probationary requirements and modify it to include Keaton, and then pay some money. But on 21 CF 3177, which is also a violation of probation, he's going to admit that. The sentence on that one, since we just added it today, is an adjudication of guilt, revoke and terminate that probation, and just give him time served. But it's all on the agreement, and a score sheet's going to be filed with by the state later on. May I approach?
Yes, sir. Thank you. Thank you, sir. Is the time on the existing probations, are they long enough for him to complete Keaton? Mr. Russell, and the reason why I ask you, I don't want to say he's got to complete Keaton before the expiration of his current probation, and he doesn't have enough time to do that.
I don't make an issue to that, Judge.
Are you modifying to extend the probation in the other cases to 3 years? Mr. Tipton, I'm just trying to make sure that I understand where I know you understand.
He's got plenty of time, Judge.
Okay. Okay. Mr. Tipton, if you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you, sir. You can put your hand down. Mr. Tipton, did you read the plea agreement?
Yes, sir.
Do you understand it?
Yes, sir.
Did you discuss it with your attorney?
Yes, sir.
Did he answer all of your questions?
Yes, sir.
Are you satisfied with his representation? Did you sign the plea agreement?
Yes, sir.
Mr. Tipton, I do accept your plea. You're adjudicated guilty on the new case. You're sentenced to 3 years probation, and that's concurrent with your VOP cases. You'll need to attend and complete the Keaton inpatient and after, excuse me, and aftercare, and it's bars to beds, so they'll transport you directly from the jail to Keaton. You'll have no contact with Lindsay Nicole Lane. You need to pay the restitution in the amount of $635.95. All monetary assessments mandated by statute or county ordinance are imposed. That's the court cost. There's a $150 public defender's fee in one case, $100 public defender's fee in each of the other cases. In 21 CF 3177, you're adjudicated guilty. You're sentenced to credit for time served. And if there's any probation that's outstanding, that's revoked and terminated. You will need to pay the $40 per month cost of supervision, but that's waived while you're in Keaton. Okay. Thank you, Mr. Tipton. Good luck to you, sir.
Mr. Jonathan Wallace.
I have two misdemeanors on these VOPs. Did they find out
time served on the misdemeanors?
The CC case current today, the overall termination is 5/15/26.
She's talking about misdemeanors, just time served on misdemeanors? Good afternoon, sir.
Good afternoon.
Thank you.
Judge Charles Russell, Public Defender's Office, for Mr. McKinney, he's the attorney of record. On Mr. Wallace's case, my understanding that the state has been provided a drop charge form, or at least shown it today. My instructions were to leave it on for trial and see what happens Thursday. Maybe we can resolve it if not.
To be clear, there's 2 victims in the case, and the drop charge is from only one of them.
Oh, okay.
So we have made essentially a time served offer for the aggravated assault. We've taken depositions in the case. So I think at this point it was a 6-month offer, and he has that credit. The offer will not remain open until Thursday.
So you're withdrawing it, revoking it today. It's not accepted.
Yes, Judge.
Adjudication of guilt.
He's previously been adjudicated.
Mr. Wallace says there's a drop charge on both, not the one we showed you today, but he claims there's one from before.
We've had depositions in the case, but I'm happy to compel them to be here.
Okay.
If we would like to go to trial, I would send a card to get them.
And the offer's gone today if he doesn't accept it.
Yes.
Okay. Mr. Wallace wants to leave it on the trial docket, Judge.
Okay. So, Mr. Wallace, here's what I hear. First off, what's my job? My job is not to talk you into anything, okay? It's just to make sure that you understand what I understand. So the state has offered you a plea of guilty, 6 months in the Okaloosa County Jail with credit for all time served. You have to pay court costs, $150 public defender's fee. They intend to withdraw that today if you don't accept it, and then we'll be going to trial next week. Is 5 years, what's the maximum sentence for Mr. Wallace?
It's a third-degree felony, Judge, 5 years.
Okay. So you could be sentenced up, I have no idea, Mr. Wallace. If the jury says you're guilty, what I'd sentence you to, no idea at all, but I want you to know the maximum downside, and it's up to 5 years in prison. So if you want to go to trial, I'll see you on Thursday, and we'll look at going to trial next week. If you want to accept the state's offer, you can do that, but just know if you don't accept it today, they're going to withdraw.
Okay.
So what do you wish to do?
Wish to proceed
To go to trial?
to the trial.
Okay. And I'll see you on Thursday, and we'll look at scheduling out the trial next week or a couple weeks after that.
Great.
Thank you, sir.
Next is Weathersby. No, not on tape. It wasn't addressed so much longer than in the past. We got in the courthouse on 21/35/77. He's terminated in the revised probation.
Oh, you want to? Why don't we say he has he can pay that during his probation?
Yeah.
The 3 years.
That'll work,
Any rest issues? Top here.
Good afternoon.
How you doing, Ron?
Good, how are
Yeah.
you?
Pretty good.
This is Mr. Broderick Weathersby. At this point, all I can do really is ask the court for a one-side continuance for Mr. Weathersby. I know Mr. McKinney's notes indicate he's trying to work something out with the state, but I don't think the state's in a position to do anything. I don't know enough about the case to push the issue at this point.
Does the state have an offer for Mr. Weathersby?
Nothing presently before me, whatever Mr. Conley said.
Mr. Weathersby, I'll see you back here no later than July 10th, but if Mr. McKinney wants to set a hearing before that, I'll see you then.
All right, thank you.
Thank you, sir.
Okay, cheers, bye. Thanks.
Wendell, Wright.
That's one case, that's the other case. This is the, whichever one's the boat, the other one's the best thing. Okay, but the boat in front. Your Honor, this is Wendell Wright. I believe that he's on the Thursday docket for 21 CF 1776. Is that the fleeing and eluding?
Yes.
That case has been announced plea or trial, so if we could leave Mr. Wright on for the Thursday docket, I do expect this probably will be a trial the second week, but Mr. McKinney can certainly fill the court in on that.
Okay. Is there any offer open to Mr. Wright that the state intends to withdraw?
No, Judge, it was withdrawn last week.
Okay. Mr. Wright, I'll see you on Thursday, and we'll look at scheduling the trial in the next couple of weeks.
All right.
Thank you, sir.
Good luck, Wendell. I think it's-
What did the gentleman in the gallery?
He wasn't on the docket.
Oh, okay. Thank you. You have anybody else in back?
Yes.
Your Honor, we do have a number of cases that we skipped over on the morning docket simply because I knew they weren't here. So the court wants to call those or?
People in back?
I just have one.
And that's waiting until 2:30. Got it. Okay. Madam Clerk, you'll bring us up to speed on everything you have other than Woodby.
We'll start with Cameron Boswell.
I thought Mr. Boswell's cases were straight continued to the July 10th docket. If I was wrong, I apologize, but I'd ask the court to continue that.
They're continuing.
Keno King Jr.
So, Your Honor, this was a case that was the 22-1368 was announced plea or trial. I talked with Ms. Davis. Mr. King and the state have been in negotiations to resolve this. The state had requested essentially to take this off the trial docket because we're really close to a resolution, and I know that especially Ms. Davis has got a lot of cases actually going to trial. So I filed a waiver of appearance for Mr. King. I did talk, and I didn't do that until after I talked to him. I talked to him twice last week. So I would ask the court to continue Mr. King, but the intention here would be to have him before the court sometime in the month of June for an early plea.
To the state? Any objection to the continuance?
No, Judge. We're just waiting on one thing, I think, really to get ironed out, and then we should have an agreement.
Okay, it's continued.
Jerry Lawson.
I have a negotiated plea for Mr. Lawson to a misdemeanor, if I may approach.
Yes, sir. Thank you. Thank you, sir.
Derek McLean.
Mr. McLean's case, it should have been continued. This is a situation where I think it's going to be trial next time. I didn't even catch he was on this docket.
Okay, it's continued.
Alyssa Guinness.
We filed a waiver, Your Honor. We were waiting on PTI paperwork from Ms. McGinnis. So a number of PTI people are going to be, as soon as we get these agreements, we'll get them filed and taken off dockets as quick as possible.
So it's continued.
Lara Burns.
Ms. Mearns, her appearance was waived today. She was only left on the docket, so to make sure that the motion to suppress was filed, it was filed, and it's noticed for hearing, I believe, on June 12th. So I would ask for the continuance to the July 10th docket, but we'll see you in the meantime sometime in the month, whatever date it was. I don't remember off the top of my head.
Yes, sir. Good, thank you.
Kelly Midget.
Ms. Midget appeared earlier today with her husband. She's on the June 12th docket, I believe.
So did we continue?
Or it might have been continued. This was the case where the husband and wife were here.
John came up first. It was continued to track together because we're just waiting on hearing from Lowe's regarding restitution.
Right. So whatever was Mr. Midget's case, the same thing. Her underlying case is continued, I think.
June 12th.
Yes, sir. For status. Okay.
Laura Miller.
The PTI agreement should have been, it looked like it was emailed to probation on May 10th. If the court wants to leave Ms. Miller on for status for the June 12th, just to make sure the paperwork's all been done.
Why don't we just continue at one side?
No problem.
Christian Moore.
This was like Ms. Mearns, Your Honor. This was kept on this docket. Mr. Moore's appearance was waived last week. I can tell the court this motion express was filed, and I know it's set for June 19th.
Okay, so it's continued.
I'm sorry, June 22nd.
Israel Israel Mount?
I have called Mr. Mount and I can't get him on the phone, so I don't know. I'll turn it over to the state.
State request, KP, sure.
20 CF 869, KPs will be issued for Mr. Mount. This is just, it's a new case, right?
It's a
20
PTI recall,
Okay.
actually, so I will continue.
How long ago was the PTI?
So I think it's a 20 CF case.
It is. I was
So-
curious when that.
I'd have to go back and look. I'll continue trying to keep getting in touch. I know Mr. Mount lives out of state, but I know when I left a message, he had a very distinctive voicemail greeting. So it wasn't just a generic, please leave your number.
He's out of state.
He does live out of state. I'll continue trying to call him. If I can get him back before the court on Thursday, I'll do what I can. But I understand certainly that.
I'm just
Judge,
trying to
I
figure
think
out.
this was brought back, I could be wrong, but just based on the notes on the file, I have one from October 20th, which is like when I believe it was entered into, and the next time I got it, I think it was set in March, like we got it back in March of 23, it looks like.
Okay.
Just for the
So,
court's
A
recollection.
KP is in the first appearance, Judge. I'm sorry.
Monty Patton?
This is another case, Your Honor, where we're waiting for the PTI paperwork from Mr. Patton, so we just asked for a one-cycle continuance.
Yes, sir.
Carla Burkett?
Mr. Burkett is a plea to no valid driver's license. May I approach?
Yes, sir.
And now approach the statute number 123.22.03 subsection 4. And it's 6 months probation. And I have provided Mr. Burkett contact information for Judicial Corrective Services and instructed him to call them Wednesday or Thursday this week.
So is that for both cases, Your Honor?
Yes, it's for both cases.
Pablo Reese?
That's the one, yeah, it's continued to September 11th.
I just wanted to make sure, just for, because I know I had spoken with Mr. Atkinson, because if you recall, it was last week, we had Mr. Atkinson's case, but he wasn't actually here. We spoke on the phone that afternoon, and I just wanted to make sure, we ended up cleaning this out to misdemeanor. I just want to make sure that you got this plea agreement. I have a copy of it in case it wasn't filed, but I just want to make sure that was handled.
Has it already been entered? I mean, you're asking whether it's entered?
I just want to make sure that you guys have a copy. If you don't, then I have a copy to make sure that the case
What's
does.
the case number?
It is 22 CF 2920. The defendant's name is Parker Knowles Powell.
What? Yeah, that.
And those are adjourned.
Okay, perfect. Glad I turned this in.
Yes, sir.
This is just a misdemeanor plea agreement. There's a score sheet that has been signed by the defendant. I need to sign it.
Okay.
I believe that at the moment, this defendant is incarcerated in Walton County, and so the sentence calls for a concurrent jail sentence that allows him to serve because he's going to be getting in jail as well in Walton County.
Okay. Thank you. Okay, so as Allison pointed out, I mistakenly, oh good, is that the person that walked in and walked out?
If I'm going to go
Good.
make sure if it is, then
Okay. Please. So, no, Chris got that. So as far as scheduling, we've got courtrooms available, we've got judges for the times that I told y'all, we've got a couple that are hanging out there that we'll know Thursday. I'll talk to the court reporters and see what they say in the clerk's office about making sure they have folks ready. And then I'll email you between now and then, the next couple days, the court reporters and clerk, and anything else that I have, just where you've got all the pieces that I have. Okay. Yes, ma'am. Does he have his client in the room? Okay, yes, ma'am. Why don't you do that? Yes, ma'am. How long do you think you need? Okay, okay. So for the last case that we have today, Wooden, we'll take a 10-minute recess while Mr. Scott speaks with his client, and then we'll finish up the docket. If anybody doesn't have Mr. Wooden on there, or they don't need the court, you're certainly excused. Thanks, y'all. Probation, I don't know if Mr. Wooden can enter a plea, so I'll need you to stay. Okay? Good. We're in recess for 10 minutes. Thank you.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestview's historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Bad Boy's Juicy Beef and Tasty Bird is located at 482 North Wilston Street in historic downtown Crestview, just 1 block from the courthouse. We open at 10 a.m. with amazing lunch specials until 2 p.m., serving incredible burgers, wings, sandwiches, and appetizers. Join us for happy hour Monday through Friday from 3 p.m. to 6 p.m. Hope to see you soon.
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just 1 block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
Alex Barthay from the UPS.
Speak with him, and I believe that he would like to address the court. Your Honor, I believe per our last hearing, Your Honor wanted to bring Mr. Wooden in to discuss his statement to me that maybe he wanted to represent himself.
Okay. Mr. Wooden, how are you? Good. So, Mr. Wooden, what are you seeking from the court at this point?
What I've been seeking is to be pro se in my case and represent myself.
Okay, why don't we get Mr. Scott, if you'll move further away from Mr. Wooden where he can take his mask off.
Yes, sir.
If you'll take off your mask where I can hear you better.
I just stand closer to him.
Okay, that'd be great. Yes, sir. So what do you want to do?
I want to represent myself. I'm present my own defense in my counsel.
Okay.
Present my own counsel and defense.
Okay. And Mr. Scott was appointed to represent you. And so you want to represent yourself. Okay. Let me find my sheet. So if you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you. You can put your hand down. So, Mr. Wooden, do you understand that you have the right to an attorney?
Yes, sir.
If you cannot afford an attorney, then one will be appointed for you. The state of Florida will pay for your lawyer to represent you in this proceeding. You've already been appointed Mr. Scott, but you don't want him to represent you anymore. Is that accurate?
Yes, sir. This would be, I don't know what the name of this hearing, but I've been to multiple mental hearings elaborating that even since the beginning that I would like to represent myself.
Okay. So let me tell you some of the ways a lawyer can help you before the trial. A lawyer's legal knowledge and experience may assist you in attempting to set a bond, reduce bond, or obtain pretrial release. A lawyer may obtain information about the case through skillful use of discovery devices. A lawyer may discover possible violations of constitutional rights and take the proper steps to address them. A lawyer may make sure the speedy trial rule and statute of limitations are enforced. A lawyer may identify and obtain favorable evidence to introduce at trial on your behalf. A lawyer can, if appropriate, file motions to exclude evidence, to suppress evidence, and to dismiss or reduce charges against you. Do you still wish to represent yourself?
Yes, sir.
Let me tell you some of the ways a lawyer can help you in deciding whether to enter a plea in the case. A lawyer can advise you as to whether entering a plea is in your best interest. A lawyer has the experience to help you work with the state and even bargain for different terms. A lawyer can tell you the advantages and disadvantages of what you might say to the court during your plea hearing and the sentencing hearing that will follow. Do you understand that you will not get any special consideration from the court just because you are representing yourself?
Yes, sir.
Do you understand how necessary a lawyer is and how he or she could help you?
Yes, sir.
You are currently charged with a homicide, premeditated, aggravated battery with a firearm, possession of a weapon by a convicted felon. Have you been provided with the charging documents that show those charges against you?
You talking about booking surgery? Yes, sir.
You're talking about what?
When I was booked in, yes, sir.
Okay. Do you understand the serious nature of the charges against you?
Yes, sir.
To the state, what is the maximum sentence that Mr. Wooden could be sentenced to?
Life, Your Honor, and it would be a mandatory life sentence if he were convicted at trial.
Okay. With parole, without parole?
Without, Your Honor.
Do you understand that, Mr. Wooden? You don't understand that's the sentence if the jury finds you guilty, that
The
you'd be
possibilities,
sentenced?
yeah, I understand the possibilities, yes, sir.
Okay. Let me tell you some of the ways a lawyer can help you at trial. A lawyer has the experience and knowledge of the entire process. Your lawyer will argue for your side during the whole trial and present the best legal arguments for your defense. Since jury selection is governed by a lot of legal procedures, a lawyer's knowledge and experience may give a lawyer an advantage during the selection process on your behalf. A lawyer can call witnesses for you, question witnesses against you, and present evidence on your behalf. A lawyer can advise you on whether you should testify, the consequences of that decision, and what you have a right not to say. Do you understand those rights?
Yes, sir.
A lawyer has studied the rules of evidence and knows what evidence can or cannot come into trial. A lawyer can make objections during the trial to try to keep certain testimony and evidence from being introduced at trial. A lawyer may provide assistance in assuring that the jury is given complete and accurate jury instructions by the court, may make effective closing arguments on your behalf, and may prevent improper argument by the prosecutor. A lawyer may ensure that any errors committed during the trial are properly preserved for appellate review later by the court. Do you still wish to represent yourself?
Yes, sir.
If you are convicted, a lawyer may prepare for sentencing to make sure that favorable facts are brought to the attention of the court. A lawyer may make sure that the court is aware of all legally available favorable dispositions. A lawyer can make sure a proper pre-sentence investigation report is prepared on your behalf. A lawyer may help bring witnesses to court to testify on your behalf at sentencing. A lawyer may make sure that any sentence is lawfully imposed. An attorney's legal knowledge and experience may be useful in filing an appeal and in seeking release on bail pending the appeal. Do you understand those advantages to an attorney?
Yes, sir.
Okay. And the probation, as I go through this, I doubt we're going to end up with a plea from this, so if you wish to leave, you can. Thank you. As it is almost always unwise to represent yourself in court, let me tell you a few of the disadvantages of representing yourself. Do you understand that you will not get any special treatment from the court just because you are representing yourself.
Yes, sir.
Do you understand that you will not be entitled to a continuance simply because you wish to represent yourself?
Yeah, I don't understand.
If-
Simply because I want to know.
Right.
No,
If you say, Judge, I need a continuance because I'm representing
Yeah, yeah,
myself,
yeah, I
doesn't mean
understand.
that you necessarily will get that
Yeah,
continuance.
I understand, sir.
You will also be limited to the legal resources that are available to you while you are in custody. You will not be entitled to any additional library privileges just because you are representing yourself. A lawyer would have fewer restrictions in researching your defense or investigating your case. Do you understand that?
If not to include, I'm representing myself, so I had rights to gather defense and information.
Yes, sir, you have the right to gather that, but you don't have...
I shouldn't be secluded from the same entitlement as a lawyer would. I'm not asking for extra or stuff like that, but...
Right, you'll be provided with the same discovery that an attorney would be. But as far as legal research and case law and things like that, you've only got what's in jail, and you only get the time and the exposure that...
But the United States provides Florida with a barcode, which is to provide people who represent themselves in this type of situation with certain things to be equal in the representation. So how would I present motions? How would I look up case documents? How would I look up case law and fully present it in a hearing or the trial if I don't have those documents?
Well, when you say the documents, what do you mean the documents?
Say if I want to look up a case law to provide an motion, but in my cell, I don't have motion forms in my cell. So how would I get motion forms? How would I be able to?
You're only going to have the resources that are in the jail. The state doesn't provide you with a law library.
Again, I say the United States provides each state with those type of. So
well, I'm telling you,
that wouldn't be on my part.
You're not being provided with a separate law library any more references than any other inmate that's in the Okaloosa County Jail.
So
you may not agree to that, but
if the facility has some type of form of legal tablet or legal research where they provide, then you inform them that, or it would be on my behalf to obtain those resources.
I don't talk to the jail and say, I mean, if you bring a motion to me and say, the jail is not letting me see something that the jail already has, then I'll certainly rule on that, but I don't communicate directly with the jail and tell them, I will not tell the jail to provide you with anything that is unique to you because you're representing yourself versus any other inmate. And that's what this is trying to take.
Okay, so the court would provide me with a colored document, and how would I review video footage and
you would be able to
cross-examine witnesses. I got the right to cross-examine witnesses.
You do at trial, you certainly have that. You're going to have limited access to do that, depositions and things, because you're going to be incarcerated. But you have, the jail will make all videos available to you. You may not be able to leave a room with them, but they'll play them for you. And you'll have access to those, yes.
How is that possible? How would the jail be possible? How would
They will make the discovery accessible to you where you can view that. Whether it's a video on a computer, they will do that.
And they have to have knowledge that I'm representing myself as well for them to grant me those resources. They don't take inmate words over the court.
Okay, if you don't get something, if the jail doesn't give you access to some video or something like that, you write up a motion, file it.
That would take a direct hand with the DA. The DA provides the evidence, the discovery.
Your attorney, if he is allowed, if you are representing yourself, your attorney will turn over to you the discovery that he's received. And then you'll be in possession of that. At least within the constraints of the jail. If it's on a DVD and the jail says you can't have a DVD because it's a security risk, then it'll be provided, the jail will hang on to it, you'll be provided access to that where you can look at it, but it'd be in a controlled environment. You know, you can't get probably binders, they won't even give you staples. So, but as far as the actual discovery, you're certainly entitled to view that.
And what about legal pads, legal pens, stuff like that?
I don't know what they do on that.
From my understanding, the United States provides a bar, and the Florida follows the bar, the code, and it states that Florida is supposed to provide me with a minimum of resources once I represent myself, including a legal pad and legal utensils.
I've never seen a case that says that, but it may be out there. Again, if you believe that you should be provided with something that you're not being provided with, you can file a motion and we'll have a hearing on it. No, we won't.
All right.
Mr. Scott, you look like you're moving around like you want to jump in on this. No?
No, Your Honor, going along with what the court's saying, Mr. Wood, I'd be happy to print out all of the discovery that can be printed and provide that to you.
I mean, no, I'm trying to get to the point where maybe, I'm entitled to, if the court provides me with backup counsel, whatever, what things he may
Standby counsel?
Yes, sir. Well, I understand you're going through the process step by step. I'm defending my life here, so I want to take tedious steps through this process. What I'm also asking is,
okay, so at the end of this, let's talk about standby counsel. First off, you've got to say, if you want to represent yourself, and that's how this ends up, then let's talk about standby counsel, okay? Okay, so a lawyer would have fewer restrictions on researching your defense or investigating your case. You're not required to possess any legal knowledge or skills of an attorney in order to represent yourself. However, you will be required to abide by the rules of criminal law and the rules of courtroom procedure. These laws took lawyers years to learn and abide by. If you demonstrate an unwillingness to abide by these rules, I may terminate your self-representation. Do you understand that?
No, I understand.
Do you understand that if you are disruptive in the courtroom, that I can terminate your self-representation and remove you from the courtroom, in which case the trial would continue without your presence?
I mean, you speak on disrupting like it's been like absurd, uncontrollable behavior, then yeah.
Okay. Do you understand that your access to the state attorney who is prosecuting you will be severely reduced as compared to a lawyer who could easily contact the state? Do you understand that?
No, I don't understand.
Okay. I mean, an attorney can pick up the phone and just call the state and talk to them. You're not going to have that much access from the jail, and I don't know what the state's procedures are as far as responding to pro se defendants, especially that are in jail.
Your Honor, I'm unsure what that is. This is a unique situation, but our general policy is that we generally only speak to defendants on the record in the communications with pro se defendant.
Okay. So, Mr. Wooden, you need to understand that.
So if I need to speak to, like, say if we was to plead or ask for a motion or something, we'll do it on here every time?
Yes,
Yeah,
sir.
I understand it completely.
Okay. The state will not go easier on you or give you any special treatment because you are representing yourself. The state will present its case against you as an experienced lawyer. If you are convicted, you cannot claim on appeal that your own lack of legal knowledge or skill constitutes a basis for a new trial. In other words, you cannot claim that you received ineffective assistance of counsel. Do you understand that?
Completely, sir.
And if I appoint an attorney to be a standby counsel, it's my understanding that you can't claim ineffective assistance of counsel for just a standby counsel. Do you understand that?
Yes, sir.
Do you understand these dangers and disadvantages of representing yourself?
Yes, sir.
Do you have any questions about these dangers and disadvantages?
No, I don't.
During the time that you were represented by counsel, did you discuss this case with your attorney?
Minor details that wasn't available. Anything that wasn't available that already didn't know. But yeah, I understand. Me and my counsel did speak about the case period.
Okay.
I didn't make no final decisions or make no, we only spoke of possibilities and stuff like that.
Okay. Okay, let me ask you a few questions to see if you are competent to basically represent yourself. How old are you?
29, sir.
Can you read?
Yes, sir.
Can you write?
Yes, sir.
Do you have any difficulty understanding English?
No, sir.
How many years of school have you completed?
All the way to senior in high school. And,
Graduated from high school?
Yeah.
Okay.
And minor college courses.
Okay. Are you currently under the influence of any drugs, alcohol, or medication?
No, sir.
Have you ever been diagnosed and treated for a mental illness?
No, sir.
Do you have any physical problem which would hinder your self-representation in this case, such as a hearing problem, speech impediment, or poor eyesight?
No, sir.
Has anyone told you not to use a lawyer?
No, sir.
Has anyone threatened you if you hire a lawyer or accept a lawyer by being appointed by the court? Has anybody threatened you?
No, sir.
Do you understand that a lawyer appointed by the court will represent you for free?
Yes, sir.
Have you ever represented yourself in a trial?
No, sir.
Do you have any questions about having a lawyer appointed to defend you?
No, sir.
Having been advised of your right to counsel, the advantages of having counsel, the disadvantages and dangers of proceeding without counsel, the nature of the charges, and the possible consequences in the event of a conviction, are you certain that you do not want me to appoint or at least keep your attorney representing you?
Yes and yes, sir.
So you do not, you do want to represent yourself?
Yeah, I do want to represent myself. I understand the nature and all that.
Okay. So let's talk about standby counsel. It's my understanding that there's kind of there's a long continuum of standby counsels. The court can say, the court's appointing a standby counsel if at any time you wave the white flag and say, okay, I need help, I'm out, I need an attorney. That's one continuum. Other ones, courts have appointed standby counsel. They don't use the word paralegal, but they use them as that if you had legal questions, if you had research questions, if you had different things, then standby counsel would do that. I have never appointed a standby counsel other than the one extreme of they're only there literally to stand by, and in the event, whether it's tomorrow, whether it's in the middle of the trial, the attorney would be ready to step in for you and take over your case and represent you as your attorney. I think there'd be some real problems with anything more than that, because the blurring of the line between what your rights are and what the attorney does, I just don't think it's fair to the attorney, for one, to say you're going to be basically a paralegal for someone. So if you want a standby counsel, then Mr. Scott would be your standby counsel, but he would only be there in the event you say, I don't want to represent myself anymore. I want Mr. Scott to represent me. Do you understand that?
Yeah. So speaking of paralegal, like consultation, like we were speaking of motions and case law. So if I was in a normal situation, I would have like a consultator that print documents and stuff for me. Like I hired myself, and basically what I'm asking is, I still can do that even though I'm representing myself. Just hire a paralegal.
Yes, sir, you can hire. Yes, sir, you don't. I'm not taking away any rights from you.
Right.
The only thing that we're determining here is, do you want an attorney to represent you in this case?
Right.
And you have the right to go out and hire a private attorney. You can hire a paralegal. You can do all those other rights that you have. I'm not taking any right away from you. Okay. Okay. You still want to represent yourself?
Yes, sir. Completely.
Okay. I find that you're competent to make that decision. There's a lot of case law that says competent to represent himself, and it doesn't mean legal thinking or any of that, but I don't have any reason to believe that you aren't competent to make the decision to represent yourself. And so I do find that. So, and I do appoint Mr. Scott as your standby attorney to be there if you decide that you don't want to represent yourself anymore.
Right.
So as far as the case to the state.
Your Honor, we're ready for trial.
Okay. Mr. Wooden, I assume that you haven't gotten all the discovery from Mr. Scott and that you're not ready for trial. Is that accurate, or do you want to go to trial next week?
To be accurate response to that would be, I would like to be able to review all the footage, review all the evidence in a wholesomeness. And if I can do that in a timely manner, then I'm ready whenever. But if not, it'll be wise to
get a continuance.
To get a continuance.
Okay. Yes, ma'am.
And Your Honor, just to inform the court and Mr. Wooden, the state was planning on the week of June 5th.
I'm sorry, what was happening on June?
We were planning on trial the week of June 5th.
Yes, ma'am.
As Mr. Scott was newer to the case, to give him some extra time, and based on the schedules of some of our witnesses, I don't know if that changes Mr. Wooden's mind at all about when he might be ready for trial, but the state has already made travel arrangements for several witnesses.
Okay, so basically what I hear is that the state's ready to go to trial on June 5th.
That is correct, Your Honor.
Okay. Mr. Wooden, do you understand that the state's ready to go to trial on June 5th if you're ready to go?
Yeah, a lot of the reason that I hadn't been in trial since the beginning in this 4 years is because it was supposed to be planning on going to Houston multiple times, and the state didn't provide their side of it. So it was many witnesses left out of star witnesses left out undiscovered. So if there's witnesses that's provided with travel or whatever, we need to depose them immediately.
Okay, I don't know how you depose somebody, Mr. Wooden. I don't know how you do that if you're in jail. They're not going to let you out of jail to depose someone. To the state.
Also, added to represent myself, I'm supposed to be provided with some form of education to deal with a jury, because I've never dealt with a jury.
No, sir, you're not, there's not
So
gonna
how do I pick my jury?
nobody's gonna
question-
educate you about the trial process. I mean, you can do that yourself, but we're not gonna, you know, nobody's gonna start a law school for you to.
So when a jury come here, we picking our jury. I just talk to them how I want to. Just
They'll be in
speak freely.
it's called the venari. The jury pool will come in, they'll be sitting in the gallery. We'll talk about the procedure of it, but not the substance of it. We'll talk about the procedure, how many people are we gonna call? We're gonna call 50 people. We have 50 people out there, and the state starts by asking their questions. Then you have the right to ask them questions. If the state objects, the same way that if you...
Everything, sorry to cut you off, but what you're telling me right now, nobody's taught me that. So how would I know that at the time being? Just show up and then you just tell me how it goes?
Closer to the time, I would just tell you, here's how mechanically, here's procedurally how it's going to work, not substantively. I'm not going to say, you know, you can't ask these questions, you can't ask these questions. But I will tell you procedurally, here's what's going to happen. The state will go first. You know, then you ask questions. You have this many preemptory challenges. You can strike a certain number. You can... Who's drinking? Not me. Should ask, what you could ask. You know, if there's an objection from the state that what you're asking isn't relevant, then I'll rule on that objection. But nobody's going to tell you everything that you can and can't do during the picking the jury, opening statements, direct, cross, you know, any of those things. Rebuttal. I mean, there's just a lot. And that's why the court, the Supreme Court, and the case law talks about us saying all these things. We've gone to law school for 3 years to try to learn most of this
I understand where you're going. So what I'm saying is, if I provide it with okay, I'm representing myself. So
yes,
tomorrow I may present motions and things that I may understand. We need hearings before we go to trial, pre-trial hearings.
Yes, sir.
We haven't had a pre-trial hearing, but you already giving me a trial date. So if I'm asking what are the process and you haven't informed me, you see what I'm saying? You just appointed me to represent myself.
Let me stop with motions. If you file a motion with the clerk, then we will set that for a hearing. We'll set it for a hearing. If I grant the continuance that you're asking for, then the pre-trial conference would be July 10th. But if you file any motions, then we'll set them for a hearing. It's got to be in writing. The state has to be, they'll get a copy through the clerk's office, so will I. I'll pull it up. I'll do my homework. We'll come in and you'll argue your motion, and then
there's no forms, there's no package where you tell me, hey, if you need to do this as you represent yourself to write the clerk. If you want to mark your motion or this and this, it needs to be in this format, in this format, presented here.
I'm not aware of any forms that you have access to at the jail that tells you.
So what do a lawyer use? What templates do they use? They just come in here and walk in here with knowledge?
They may have their own library. They have access by computer to different services that they pay for. These private counsels do. So yeah, they've got more than a blank legal pad if they pay for that. Right. There are different publications, but
This is all new to me, sir. That's just obtaining, you know.
Yes, sir.
Okay.
You're, as it says in here, you're going to be. You certainly don't have the resources that your attorney would have.
Yeah, but I shouldn't be anything the minimum. I shouldn't be refused the minimum.
I'm not refusing you anything.
My facility doesn't have a law out there, so it's not like I can go in there and.
You only have what's in the Okaloosa County Library. And if
Which is nothing.
If you don't think that's enough,
This is absolutely nothing.
then I would suggest, if you don't think that's enough.
The court, I'm just being honest when it comes to my rights. I'm almost 30 years old. I understand every one of my rights. I'm from Texas. I wouldn't even have to argue none of this right here. I would have had a package stacked this tall right here to sign out to say that I did receive what I was supposed to receive. That's all I'm getting at right now, sir. So I'm not getting nothing. I'm sitting here asking you things that I should be told and not asked.
All I can tell you that you will receive is the discovery that the state has provided. I can't say that you have the ability to depose anyone.
That's you taking 50% of my defense right there.
I'm not taking away your defense. I'm just telling you what
you the judge. You telling me I can't depose nobody before I go to trial?
I'm not telling you you can't depose anybody, but I don't think you're going to be able to pull that off in jail. I don't know how you're going to
Can I get a pre-release? Can I get a pre-release?
Can you get a what?
Pre-trial release?
You can file a motion for a bond, and we'll have a hearing on that.
All right, fine.
Okay? Still want to represent yourself at this point? Okay? I do grant the motion to continue. So, Mr. Scott, if you'll provide Mr. Wooden with all the discovery, and you are the standby counsel, under the definition that I just gave.
Yes, sir.
Okay? So I'll see you back here on July 10th in the morning, or whenever the inmates, it may be via Zoom in the afternoon. If you file a motion before that and we've got hearing time, then we'll have a hearing then.
Yes, sir.
Okay. Yes, ma'am.
And Your Honor, that would be over the state's objection, just for the record.
Absolutely.
Because we have already made a significant amount of travel plans for out-of-state witnesses. We do not have any new witnesses to disclose. Any witnesses that Mr. Wooden's discussing would be reciprocal witnesses. The state's already disclosed all of their witnesses. We do plan to disclose some new contact information for witnesses. Tomorrow, we'll have that served upon Mr. Wooden at the Okaloosa County Jail, just so he knows that's coming for the record.
Okay. So in the future, everything that you have to serve on the defense, you send directly to Mr. Wooden.
Correct, Your Honor.
Okay.
And we would courtesy copy Mr. Scott, just because he's standby counsel.
Good. That's great. Okay. Thank you. So I'll see you no later than July 10th.
Let me just say this. She's saying everything on her part. It's my defense. That's the number one thing here is my defense. What if I have witnesses that I would like to include and you just numb me out the whole situation? We're not going to do this before I leave. It's going to be clear.
I don't understand. I can't understand.
If she's saying that she's ready or whatever, but
Yes,
from my last understanding, we wasn't done deposing all the witnesses.
Okay.
The star witnesses was not available. So if they are now, it has not been told to me, or it's not new, or no discovery, no depositions have been presented to me.
Okay.
Which she would have to tell me right now, but she did not.
She would have to disclose to you who her witnesses are.
Number two, I may have a defense of witnesses that I provide in there also. So to rush a proceeding or
I'm not rushing
to skip past without my defense.
Yes, sir.
Will be completely absurd because if one of my witnesses may not be available till August or something like that, and I have the right to argue that. So
okay, I'll see you on July 10th for the pretrial, and at that time we talk about scheduling it for trial. And you say, "I'm ready for trial. I'm not ready for trial." We'll talk about it at that time, but I'm not scheduling a trial at this moment. Okay, just a pretrial.
All right.
Okay.
Yeah.
Okay. Thank you, sir.
Your Honor,
Yes,
if I could
Mr.
get
Wooden,
some
hold on.
guidance-
Yes, sir.
If I could get some guidance from really anybody, what format that I should provide that discovery to the jail to provide to Mr. Wooden, whether DVDs, thumb drive, I don't know what technology
Mr. Scott,
that has.
if you'll talk to the jail, I would ask them.
Yes, sir.
Because I don't know their rules either. I just know in the past, there have been certain things that they haven't been able to, you haven't been able to give to an inmate, and they've had to accommodate by giving them a wiped off laptop that they sit in the room and use, and they're just different security concerns. And I don't know.
I will reach out to the jail and copy you and make sure that we get with the jail to provide discovery.
Thank you. Thanks, Sean. Thank you. Court is adjourned.